All right, let's talk about one of Canada's most powerful and, yeah, most controversial constitutional tools, Section 33, better known as the Notwithstanding Clause. It's a concept that gets people really fired up. But what is it really? And why on earth does it even exist?
But it all boils down to this one single question. When a law passed by people we elect bumps up against our fundamental rights, who gets the final word? Is it the politicians or is it the judges? This is the core problem the Notwithstanding Clause was designed to address.
So to really wrap our heads around Section 33, we've got to first understand these two powerful ideas that are always in a kind of delicate dance with each other in our system of government. Okay, so on one side, you've got parliamentary sovereignty. This is the idea that the people we elect to represent us, they have the ultimate power to make laws. But on the other side, you've got judicial review. That's the power of judges who aren't elected to look at those laws and say, nope, this one breaks the fundamental rules of the Constitution. It's a classic democratic tug of war. So how did Canada figure this out? Well, you might be surprised to hear that Section 33 wasn't some kind of accident or a typo in the Constitution. Not at all. It was actually created on purpose as a great political compromise during those intense negotiations that gave us the Charter of Rights and Freedoms. You have to picture it. Back in the early 1980s, the provincial premiers were really nervous about giving courts the final say on everything. They were worried they were creating what they called a judicial aristocracy. So they hammered out a uniquely Canadian deal. We get a powerful new charter to protect our rights, but there's a legislative override, Section 33, to make sure our elected officials still had the last word when they felt they needed it. Okay, so that's the why. Now let's get into the how. How does this controversial tool actually work? Let's break it down. It's actually pretty straightforward. A government basically stands up and publicly declares that a specific law will operate in spite of, or notwithstanding, certain rights in the Charter. It's like putting a big, bold asterisk on the legislation, saying, we know this might be an issue, but we believe it's necessary. But, and this is super important, this power is not a blank check. There are huge limits built right in. A government can use it on things like fundamental freedoms or equality rights, but it can't use it to, say, cancel an election or take away your right to vote. No way. The core democratic machinery is completely off limits. And the Supreme Court has made its role here crystal clear. It's not their job to decide if a government has a good reason for using the clause. All they do is check the paperwork, make sure the government followed the rules and used the right words. The why? Well, that's a political question for voters to decide, not judges. And this might be the most clever part of the whole design. There's a ticking clock. Any law passed using the Notwithstanding Clause automatically expires after 5 years. Poof, it's gone. If a government wants to keep it, they have to stand up and pass it all over again, in public for everyone to see. That 5-year clock is everything. It's the whole reason its defenders call it a democratic safety valve instead of a rights-destroying weapon, because it's all about one thing: accountability.
And here is the bottom line. When a government uses this clause, they know they are making a huge political statement, and they know they will have to answer for it. Think about it. Judges have jobs for life. They're shielded from public opinion. But politicians, they have a very important job interview every few years with us, the voters. So what you get is this built-in, unavoidable cycle of accountability. The second a government pulls this lever, bam, the debate ignites. The media, the opposition, the public, everyone starts talking. And that 5-year deadline means the government can't just hope we all forget about it. It forces the issue right into the heart of the next election campaign. So what this all adds up to is a system where the ultimate authority, the final referee in these big disputes, isn't the courts, and it isn't even the politicians. The final referee is the public. And that is the absolute core of the argument for the clause. Supporters believe that when you have one of these profound disagreements between what the courts say and what our elected legislature wants to do, the tie-breaking vote should go to the people we can actually fire at the ballot box. And yeah, that 5-year limit is no accident. It's specifically calibrated to roughly match an election cycle. It's designed to force a conversation. You can almost think of it as a dialogue between the courts and the legislature, where we, the voters, get the final say on who was right. So from this point of view, the clause isn't a bug in our system, it's a feature. It's a mechanism put there on purpose to ensure that on the really big society-shaping issues, the will of the people expressed through their democracy can ultimately prevail. The argument is, it's not anti-rights, it's pro-democracy. Which, of course, leaves us with the big question we have to grapple with today.
In our modern democracy, is this intentional balance, this uniquely Canadian democratic safety valve, is it still the right one for our future? It's a debate that gets to the very core of our constitutional identity, and definitely something to think about.